Okay, and the third panel today is on delegations and criminal law. It's moderated by Craig Lerner. He's a professor of law at the Antonin Scalia Law School, where he served as Associate Dean for Academic Affairs. Before joining the faculty, he served as Associate Independent Counsel in the Whitewater investigation and clerked for Judge James Buckley of the U.S. Court of Appeals for the D.C. Circuit. Craig, thank you so much for joining us today.
Thank you, and we're joined by two very distinguished young law professors in the area of criminal law. Don't laugh. I have Brenner Fissell on my immediate right. He graduated from Georgetown Law School, clerked on the Ninth Circuit and on the Court of Appeals for the Armed Forces, and is now an assistant professor at Hofstra Law School. And Carissa Hessick, who graduated from Yale Law School, clerked on the D.C. Circuit, and was a fellow at the University of Chicago Law School, professor at Arizona State, and is now a distinguished professor at the University of North Carolina Law School. So take it away.
Thank you. So it's great to be here, especially I know the paper has benefited from the workshop that Adam referenced immensely, especially some references to literature on state non-delegation doctrines, which I would not have known about but for the conference. So in many ways, this project was actually motivated by a tweet that Carissa sent out after Gundy was, cert was granted in Gundy. And she said, I think there may be a non-trivial argument that the non-delegation doctrine should apply differently in criminal cases. And so I sort of set out to attempt to provide one, and not a trivial argument. And so I actually disagree when George Will says that the ultimate case of a delegation is a declaration of an emergency. I think the ultimate case of a delegation is when a branch other than the legislature is empowered to imprison people, for example. So that's what we're talking about today. So what do these laws look like, these delegations? These delegations are normally statutes that incorporate by reference an entire chapter of a regulatory rulemaking. So it'll say something like, violations of this statute or of regulations promulgated under this statute are punishable as a misdemeanor. So for example, the Food, Drug, and Cosmetic Act, which was brought up, punishes misbranding of food up to 1 year imprisonment, delegates to the Secretary of Health and Human Services power to create regulations, and it punishes those regulations similarly to statutory violations, violations of those regs. So for example, here's one, and I get some of these from the Crime a Day Twitter. I don't know if you follow that. But many of the Crime a Day Twitter's posts are actually administrative crimes. They're not statutory crimes. The ridiculous crimes that this Twitter feed highlights are ridiculous, and they're determined by agencies. So for example, did you know it's a federal crime to label vermicelli as spaghetti, or spaghetti as macaroni? Vermicelli is cord-shaped, spaghetti is tube-shaped or cord-shaped. Macaroni is only tube-shaped. And there are also regulations on how thick the noodles can be. So we've elevated these regulations into crimes when we have these penalty provisions. There's a Colorado regulation that empowers the director of the Revenue Department to promulgate regulations, quote, related to the sale of alcohol. And he's promulgated a regulation that prohibits people in bars from, quote, touching or fondling the buttocks of another person. This is a regulation that is backed by a criminal sanction. And my favorite example, does everyone know that it's a crime to swim in the Potomac? This was originally, I believe, decided by the city council, but then that law expired or was repealed, and the city council then empowered the director of the Department of the Environment to promulgate regulations based on water pollution, and those regulations were punishable as misdemeanors, and the director then imposed a ban on swimming in the Potomac. How many of these are there? Well, the American Bar Association has been unable to determine how many federal statutory crimes there are. So, in fact, we don't know how many of these crimes there are either. The number 300,000 has been tossed around, although I'm not sure that that's accurate. I think it's many thousands. We don't really know much more than that. Gandhi has been discussed. I think another case which is sort of emblematic of the judiciary's take on these issues with respect to the non-delegation doctrine is a 1991 case called 2B, and that was reviewing the Controlled Substances Act. So in the Controlled Substances Act, the Attorney General was empowered to schedule drugs and make them possession or manufacture of these drugs a federal crime, and he in turn delegated his delegated authority to the DEA administrator. And of course, so therefore, the federal drug war is premised on decisions made by an agency. So the court, non-delegation challenge was raised, and the court said, our cases are not entirely clear as to whether more specific guidance is required in the criminal context. And then they said, even if that were true, the delegation in 2B is constitutional. But they did at least raise the question that maybe there would be a different analysis in criminal law, and that's what I think some of us thought might be behind the cert grant in Gundy. As it was mentioned earlier, the oral argument indicates that they're probably not going to be doing anything extreme. So my paper is trying to present this more theoretical argument as to why we think criminalization by an administrative agency is a bad thing. And I'm not saying it's unconstitutional. It clearly is constitutional under a long line of precedent, but why is it a bad thing? Why is it illegitimate as a matter of our political thought? And I start from an observation about the nature of criminal sanctions that many others have observed. And this is a quote from the Supreme Court. This is from a rule of lenity case, and this is a case called Bass. Because of the seriousness of criminal penalties and because criminal punishment usually represents the moral condemnation of the community, legislatures and not courts should determine criminal activity. Define. So legislatures and not courts, does that argument not apply equally to the executive, legislatures and not the executive? So in Bass, they talk about the seriousness of criminal penalties and the moral condemnation of the community, and I address each aspect of the criminal sanction and tie it into a requirement of democratic criminalization. So community condemnation, if you believe that that state punishment by the government represents community condemnation, then the determination of the conduct that is punished should be determined by the community, meaning more than an agency relying on its expertise, meaning all of us. So democratic criminalization. And if you deprive people of liberty. We live in a so-called liberal, lowercase l, modern liberal state where people are presumed to be free and that deprivations of liberty must be justified with a high burden. So normally, we would think that one must consent to have one's liberty removed through, and this consent is mediated through some democratic institutions, but we are at least involved in the decision that eventually results in our own liberty deprivation. That's not the case with administrative crimes. So this does result in some curious crimes that I'll just highlight one. So if you go back to the Potomac ban, you might think, well, none of us would really want to swim in the Potomac. You might also think that the legislature would pass a similar law. So therefore, the fact that the agency has done this is not a big deal. But in fact, the agency actually took notice and comment on this in 2012, I believe. And they received no comments in favor of the ban. They received many comments opposed to the ban, mostly from triathlon groups. And their response was, quote, "The department's decision must be based on data and experience relating to public health and safety," end quote. So basically, data and experience, not public opinion. So this is an example of an agency punishing people in the name of the community that opposes the punishment that they are meting out. So that's all I have.
Thank you.
Great. So let me start by saying that that I was really surprised when Brenner mentioned that that he undertook this project in part because of a tweet, because I have an ambivalent relationship with Twitter, sort of a love-hate relationship, and I'm glad to see it spawning something more than just dismay. I really, really appreciate him undertaking the project of trying to come up with a thoughtful and sophisticated explanation for why we might want to treat criminal laws differently when it comes to the non-delegation doctrine. I appreciate it for one thing because up until now, I don't think the explanations we've been offered have been particularly thoughtful. So in his paper, Brenner goes through some cases, some opinions authored by Justice Brennan, some previous academic work in the area, and all those people end up saying is, well, criminal sanctions are severe. Okay, well, that doesn't necessarily tell us that we necessarily ought to have a different rule, and I appreciate the effort to try to articulate one. I especially appreciate the effort to articulate one because I think if we want to have criminal laws be the product of democratic bodies rather than agencies, it's important to try to articulate a distinction between criminal laws and other laws. And that's because I feel as though the legal views that have been expressed at this conference today might not be representative of the broader legal community, right? Agencies are pretty popular, right? People to the center left, people to the center still like administrative agencies and like them doing things. And in fact, we got where we are right now in the doctrine of criminal law in part because the courts saw the interpretation of criminal laws as no different than the interpretation of economic regulations. If you want to learn more about that, there's this amazing paper by this woman who teaches at San Diego called Mila Sahoni called Notice in the New Deal, in which she explains how the rule of lenity and a number of other doctrines really got eviscerated by the post-New Deal, right, by the New Deal court right after the switch in time that saved 9. And I personally think that there are a lot of people who are committed to keeping the administrative state, but who might be open to an argument that criminal laws ought to be different. And so as a practical matter, I think it's worth trying to articulate that difference. I hope that there are also judges who are open to that argument, because despite the fact that we have a number of, I think, high-profile judges who are reconsidering things like Auer deference and Chevron and so on and so forth, they still seem to be pretty popular. So where does that leave us? Well, Brenner gives a couple of different arguments about why we might want to think about criminal laws differently. I want to push a little bit on at least one of his arguments. And then I actually want to talk a lot about how delegation in the criminal law looks different than I think people think it does, even without the involvement of agencies. And then I want to offer a really sort of tentative thought about how we might try to distinguish criminal laws from non-criminal laws when it comes to issues of delegation. Okay, so the specific argument that Brenner makes that I want to push on is the argument about the expressive nature of criminal law, right? The argument that criminal laws reflect condemnation in the community, and because of that, we need to have a representative body or a democratically accountable body making those sorts of decisions. It makes an awful lot of sense, but I think the argument makes a lot of sense in part because of the specific examples that Brenner chooses, right? The macaroni one was super effective. I do worry, though, often when I'm convinced by an argument because of the great examples, that the argument might seem less convincing if we use some different examples. So I thought about it for a little while, and I tried to come up with a different example. You guys can tell me if you think it's effective or not. So let's talk tax reform for a second. Imagine that Congress decides to sit down and enact comprehensive tax reform. They decide when people should take deductions, what the marginal tax rate should be, the earned income tax credit, all of these sorts of things. And they have to debate about what percentages to use, what dollar caps to use. And then they also, at the end of figuring out all of these things, include a provision that says, if you knowingly and if you willfully fail to follow these rules, you're guilty of a felony. Now, Brenner would tell us that that's totally okay. But imagine instead of enacting those substantive tax rules itself, Congress asked the Treasury Department to do it. Said to the Treasury Department, look, you figure out what the right marginal tax rate ought to be, and you tell us what the right income cutoff for the earned income tax credit is, and you tell us what the deduction ought to be for having kids or healthcare expenses or so on and so forth. But Congress still decides to enact a law that says if you don't follow those tax rules, you've committed a felony. Brenner would tell us that's not okay. He'd tell us it's not okay because the Treasury Department, in deciding where to set the marginal tax rate and the deductions and so on and so forth, wasn't making decisions about what deserves condemnation. I would say if Congress had made those substantive tax decisions, they also would not have been making decisions about how and when to condemn people. And that's because if you look at the debates surrounding things like tax reform, Congress is talking about what's the right economic rule. Maybe they're talking about morality, but they're talking about morality in terms of like redistribution, right? Or we want to encourage people to adopt, and so we're going to create an adoption tax credit. The setting of those substantive rules is not an exercise in condemnation. The decision that not following the rules should result in a felony conviction, that's the exercise in condemnation. And that's why when we saw tax reform recently, we didn't see anyone saying paying 20% of taxes rather than 21% of taxes should get you in jail. That's not the exercise that they engage in. So I wanted to push on that argument a bit. At the same time, I don't want to somehow pretend as though delegation is foreign to the criminal law. And I'm assuming that a lot of the folks here spend more time thinking about administrative law than they do about criminal law. So I thought I'd tell you a little bit that even though I agree with Brenner, I agree with him that delegation in the context of criminal law is problematic, at the same time, I'd like to emphasize how widespread it is. It's widespread without the involvement of agencies, save one, right? The Department of Justice and the executive agencies that exist in the states that enforce the criminal laws. In fact, there is so much delegation to executive officials that I would say we have less transparency and less accountability in the enforcement of our criminal laws, and I might even say the setting of the boundaries of our substantive criminal law than we do when it comes to the setting of EPA regulations and other more administrative matters. Why is that? Well, that's because the sorts of criminal laws that get written, especially nowadays, delegate a ton of power to prosecutors. They don't set the outer boundaries of what's supposed to be legal or illegal. They give the power to prosecutors to decide that on a case-by-case basis. Let me give you some examples. Child endangerment statutes are usually written in a form that says something along the lines of it's a crime to place a child in an unreasonable, risky situation. That asks enforcers to decide what's reasonable and unreasonable. And a lot of enforcers have started to use that power to prosecute people in situations that I'm not so sure we'd all agree are a crime, right? There have been a bunch of arrests and prosecutions for parents who leave their sleeping toddlers in the car as they run into the pharmacy to pick up a prescription. So that is to say, it is a felony to decide not to wake up a sleeping 4-year-old who's sick and who's why you're at the pharmacy in the first place, drag her across the parking lot and into the store to pick up the prescription for her. People have been arrested and prosecuted for this. It's not just these sort of imprecise laws that create these problems. We also have overly broad laws. I'll give you an example from my home state of North Carolina. So North Carolina, like a lot of states, we outlaw gambling. A prosecutor found out about a poker game that was going on at a local retirement home where the elderly people were playing nickel and dime poker. He prosecuted them because there's no de minimis exception in the statute. And he was well within his rights to do so. And when asked about this, a state legislator said, well, I mean, we're not going to change the law or anything like that, but one hopes that prosecutors would use better judgment. This is no accident. Legislatures are delegating this power to prosecutors on purpose. And they're often doing it because they're worried that if they write narrowly tailored laws, that bad guys might get away. They want prosecutors to have this power, and they give prosecutors a lot of power through really punitive laws to make sure that prosecutors not only start these prosecutions, but that they can avoid juries and even bargain to figure out what the specific sentence is. So it's not just that legislatures are delegating what I would say is sort of the legislative function to these prosecutors. It's that they're doing so in a way that allows them to circumvent the separation of powers for conviction and sentencing as well. And let's be clear, prosecutors make these decisions with their own set of with basically like their own substantive law, right? We saw this when James Comey testified in front of Congress about why he wasn't going to recommend that Hillary Clinton get charged for her email server. I think there's an extremely compelling argument to be made that Hillary Clinton violated a federal statute forbidding the mishandling of classified information. Like, yeah, maybe she was going to win on the mens rea issue, but like her conduct fell comfortably within the statute. But Comey didn't say that, right? What did he say? He said no reasonable prosecutor would bring this case. And he said that because the Department of Justice, he explained, the Department of Justice only enforces this law when there are aggravating factors present, like if the person lied to investigators or they'd removed lots and lots of confidential information. So basically what Comey was saying was Congress wrote one statute and then the Department of Justice wrote a different statute. And the public had no idea what the terms of that new statute were. We wouldn't have known about it if it hadn't turned into this big national scandal and Comey hadn't gone before Congress and testified. But this happens all the time, right? I mean, yeah, the posted speed limit is 55. Are you going to get a speeding ticket if you're going 56? I mean, you could, but you're not going to. What is the speed limit? What's the real law? You don't know. I don't know. Law enforcement knows, and law enforcement can change that law at any moment and does not have to apply it in a consistent way in cases going forward. And they don't have to explain it, and the public has no idea what these unwritten rules are, and neither does the legislature. I should say, by the way, Congress and legislatures do this on purpose, right? So a few years ago, when Senator Mike Lee and others were trying to change the mandatory minimums associated with certain drug crimes, Chuck Grassley was like, no way, we aren't gonna reduce these sentences. And Lee and others are like, but you don't think that that's the right sentence for this amount of drugs? And Grassley is like, yeah, no, I'm not saying it's the right sentence. I'm saying that the sentence has to be that high so that prosecutors can get people to plead guilty and cooperate. And then he pulled out some statistics that he had from the US Sentencing Commission to say, look, if you look at how much drugs people actually have when they're getting convicted of this crime, it's not really being used for the people that fall within the statute, it's being used for other people instead. And it's not just Congress, right? This isn't just a federal problem. In the state of Utah, they have a criminal law on the books that forbids polygamy. And a lot of people in the wake of Lawrence and other cases are like, we shouldn't have this law about polygamy, like that seems wrong. And the folks in Utah are like, no, right? The prosecutors are like, no, we need this law. We need this law because there are some religious sects that live out in the desert, and they have these child brides, and we have like these really serious problems with child sex abuse. And it's like, okay, but that's also a crime. And they're like, yeah. But you know what? It's really hard to prove those crimes. It's way easier to prove polygamy. So we'll just go out and we'll figure out who we think is actually engaged in child sex abuse, and we'll charge them with this other thing that we probably don't think should be a crime in the first instance because it's easier to prove. It's a problem, right? I think it's a big problem. And let me tell you, we have this problem because people like it, right? What type of crime do you dislike? Is it drugs? Is it domestic violence, right? So folks on the right, maybe it's drugs. Folks on the left, maybe it's like domestic violence or like sexual assault or whatever. You'll see people argue that we ought to change the substantive definitions of those crimes, not to match up with what they think is wrong, but to make it easier to convict people that they think are doing things that are wrong, to give these tools to prosecutors. And I mean, Elizabeth Warren just put out a report about this with respect to white-collar crime really recently, right? One of the things she says in her report is we can't have a mens rea for these sorts of statutes, not because she cared whether people were committing the crimes without mens rea, but because it would be too difficult for prosecutors to have to prove mens rea. It's endemic to our system. Unless we all decide that what we don't need is a nimble criminal justice system, this is going to continue. All right. I should say, though, I'm talking about how much delegation there is in the criminal justice system. It's not just about agencies. It's all over the place. But that doesn't mean I don't think we can draw a distinction between delegation issues when it comes to criminal law and delegations more generally. In fact, I think it might even be possible for us to draw a constitutional distinction. Why is that? Well, the Supreme Court has a couple of rules that they really just use for criminal laws. They have rules about lenity and prospectivity and vagueness. They're all kind of related to the Due Process Clause's requirement of notice, but some of them also have features of separation of powers associated with it. You see, for example, in the void for vagueness cases, the older ones, you see the Supreme Court saying that you can't have vague laws because they delegate the question of legality to prosecutors, judges, and juries. You have, even in the DiMaia case, which was decided, I think it was just last term, the majority in that case made reference to the vagueness doctrine as being a corollary to the separation of powers. And Justice Gorsuch went even further than that in his concurring opinions to say that he thought the void for vagueness doctrine was equally derived from the Due Process Clause and the separation of powers, which I don't think anyone's ever said that before. Like it's certainly not a judge. There is a great paper by Nathan Chapman and Mike McConnell talking about due process as separation of powers, and they make, I think, a pretty good case about how the vagueness doctrine should really be conceptualized as the separation of powers. So what does the court do in these vagueness cases? They say vague laws improperly delegate questions of legality to these other actors. So they could conceivably say that when you have an explicit delegation, right? An explicit delegation to someone else could arguably run afoul of these same separation of powers principles that the court has said is unique to criminal cases. And yes, I should put a flag on that and said in Sessions versus DiMaia, they included removal proceedings and deportation and said that's also really bad and problematic. But okay, fine. So criminal cases and deportation cases. What about all of the stuff that I said before about the extent to which the criminal justice system already massively delegates all of these questions to prosecutors? Well, that's the interesting thing. The Supreme Court knows this. They've even gone so far as to acknowledge it, right? They've gone so far as to say that the power that prosecutors have can lead to terrible sort of abuse and discrimination, which is one of the major reasons that they give for the vagueness doctrine. But the Supreme Court treats that delegation question differently if it's sort of an accident, right? If it's sort of a spillover effect from laws that are overly broad or overlapping or the leverage that prosecutors have when it comes to plea bargaining. They've taken a sort of form versus substance approach. And when the form of the law, the vague law, delegates, they've said that's not okay. So I think it's possible that they could say if the form of the statute is an explicit delegation, that is also not okay. I say it's possible. I have no idea what they're going to do in Gundy, right? You guys heard from people this morning who know way more about Gundy and way more about the court than I do. But I do think it's possible to make a principled argument for why the non-delegation doctrine should be applied differently when it comes to the criminal law. And frankly, I hope that we do. Even if we're never going to sort of like vindicate those due process values, as the court doesn't seem willing to do when it comes to overly broad laws or laws that use like qualitative judgments like reasonableness, at a minimum, you would think that they would police the explicit delegation of this power, a power that they've been very clear is a power that's supposed to be held by the legislatures. Thanks.
want to respond?
Just what, well, I one response, at least so if my criticism is a democratic deficit, and you should have a lot to say about this. Does it not matter then that local prosecutors are elected?
Ooh, I do have a lot to say about this. It is true that the vast majority of local prosecutors are elected. It is also true that we almost never know what their prosecution policies are. In fact, the recently elected prosecutor in Boston, she made clear during her campaign what her non-prosecution policies were going to be. So she was like, theft under $200, we're not going to file charges. And people were outraged. There was an ethics complaint filed against her. They're like, how could you possibly say this? Not how could you possibly do this? How could you possibly say this? That's outrageous. So there's a sense in which I think the public knows that the laws aren't always going to be enforced, but we also don't have access to the policies for when they're not going to be enforced. And maybe more importantly than that, we have reason to think that most offices don't have policies about this. They leave these decisions to line prosecutors. And line prosecutors are not elected. In fact, line prosecutors often enjoy civil service protections, so they can't get fired. And there's some evidence that shows even if you have a new elected prosecutor come in to office, they're not very effective at changing office policies. They have a really hard time changing office policies. And then finally, we have some studies of media coverage in prosecutor elections where it is clear that policies about prosecution and non-prosecution do not get reported on. And if you try to find them out, most prosecutors will tell you that they're not subject to their state sunshine laws and they don't have to tell you.
I do think there's a federalism angle here, which I'm not sure your paper addresses so much. Isn't there a difference between Congress delegating to an agency or a court the power to define crimes versus a state legislature doing that? And I think I'm thinking of common law crimes, which are, of course, not permitted in the federal system, but I'm not sure I agree that they're uncommon in the states. They're utterly common. In Virginia, for example, there are dozens of very important common law crimes, that is to say, statutes that simply say manslaughter is punished as a Class 5 felony. That's it. Mm-hmm. Courts, you figure it out. Assault and battery is punished as a Class 1 misdemeanor. Courts, you figure it out. So, I mean, I think state legislatures are regularly in the business of delegating to courts the power to define crimes. And then the question arises, why is it so different to delegate the same power to executive agencies? So that's one point I would make. The other point I would just be, sort of to play the skunk at the picnic here, maybe hopefully to be a little interesting. So the swimming in the Potomac point. So it's pretty undisputed that in the 60s and the 70s, the Potomac River was an environmental catastrophe. And that's when these bans on swimming sensibly originated. And then, so here's a narrative for you. Over the course of decades, there were many local and federal regulations that were passed, often backed by criminal penalties, that regulated the disposal of waste in navigable waters, and the Potomac River improved tremendously in its quality. So much so that actually recently regulators have even loosened restrictions on the ban on swimming, and they're probably poised to continue loosening those restrictions if the water quality continues to improve, if the regulations continue to be zealously enforced. So why isn't this a Bernie Sanders success story of, regulations improving the quality of life, administrative expertise deployed with Aristotelian prudence, and all making the world a better place? So I mean, that's not a argument for the withdrawing the administrative state. That's an argument for the administrative state, isn't it?
Yeah, I mean, yeah, it's great that the river's cleaner and maybe the regulations had that effect. But I mean, again, the regulation it prohibits swimming in the Potomac. It's not clear how swimming in the Potomac will hurt other people. It's actually a paternalistic offense. Don't you agree with that?
I agree, but we have tons of paternalistic offenses.
True. I think there are probably more paternalistic administrative crimes than there are statutory crimes, because I think paternalism is a bit of a harder sell to political majorities than it would be to an agency. So your point about common law crimes is absolutely correct. Carissa at lunch corrected me. She has an article coming out, or is out, right? As it turns out, there are a lot of common law crimes. I say there is a trend away from common law crimes. It's disfavored. It's surprising to hear that manslaughter is judicially defined. Seems problematic to me. On the federalism issue, I actually learned this at the paper workshop from this conference. It's interesting that most states have an actual non-delegation doctrine that's enforced. So while most states also have common law crimes, they have a so-called strong non-delegation doctrine, and they actually have non-delegation provisions in their state constitutions. So that was surprising to me because I thought that most states would go along with the Supreme Court's jurisprudence. Apparently they do not. When the last study that was done was in 2000, I doubt much has changed. Yeah, that's all. I mean, so you think the cleanliness of the Potomac is thanks to it's a success of the administrative?
I'm sure Bernie Sanders would point to it, and my guess is that many Americans think so.
Right, and I guess this is a good point about the paper. Administrative crimes might have really salutary effects for welfare. They're still not democratic, so it's a critique of the provenance of
What
them.
about
It's
this? So I'll turn it over to the audience for a second. So I was, like Carissa, horrified to discover that the federal government specifies the diameter of vermicelli versus spaghetti. It seems unbelievable to me, horrific. But my horror would not be in any way soothed if I were told that the commands emanated from Congress versus a federal agency.
Yeah.
So to address your concern, why couldn't Congress simply enact a law tomorrow that said, herewith, we incorporate as part of Title 21 of the U.S. Code all of the regulations governing branding in Title 21 of the CFR. So that would entirely address the democratic deficit point, but not in any way soothe, I think, our horror that the federal government is specifying the diameter of vermicelli and attaching criminal penalties to that. So,
So you want to open it up?
yeah, we'll turn it over. So anyone else? Yes.
Is delegation to the judiciary really delegation? Alternatively, you could look at common law, at states with common law crimes, and say that, well, Virginia is a good example of manslaughter and other common law terms that they use, that they're not delegating to the judiciary, they are borrowing from and handing back to the branch which for centuries, going back in the English common law tradition, they're drawing on 800 years worth of jurisprudence, which is very different, I would suggest, from delegating to a brand new, historically speaking, brand new agency.
Yeah, let me, jump all over that. Like, yes, 100% yes. And like, let's be clear, the common law crimes problem is, first of all, it's even worse than in Virginia. North Carolina doesn't have a statute for robbery. I mean, don't get me wrong, like people who commit robberies go to jail in North Carolina, but like, because, we rely on the cases that are like, robbery's a crime. But yes, I get it. We have United States versus Hudson and Goodwin, but I think anyone who spends any time with the federal criminal justice system would tell you there are common law federal crimes, right? What's honest services fraud? How do you violate the Sherman Antitrust Act, right? And that's not even, right, that's not even the reference that you're making to, well, they can look at the common law, which is a substantive law with elements. Nobody knew what unfair competition was when the Sherman Act was enacted, and they were just like, well, the courts will figure it out, right? So like, I worry that Hudson and Goodwin sort of like tells us something about the federal common law that is sort of not true. I'd go beyond that to say, I think you're right to point to the history of common law crimes, because I think that there's a constitutional argument to be made about that for the separation of powers, right? Look, I'm not a constitutional law person, but Article 1 says the legislative power, great. Article 3 says the judicial power. And there's a great set of articles by Stuart J. talking about how there's reason to think that the phrase the judicial power included the power to recognize new common law crimes. And so it's just not so clear to me that a delegation to the courts is a delegation. I mean, if you go back and look at what happened, legislatures really only started writing crimes kind of recently. And if you look at the founding generation, like almost every single one of them at some point made a statement, some of them were private and came out later when we published their letters, that they believed the federal government had the power to prosecute for common law crimes. Jefferson thought that. They changed their minds later when like the Federalists and the Republicans kept throwing each other in jail for sedition and libel. That's why they, and then they had to wait until they had enough people on the court to decide Hudson and Goodwin. So like I don't think we should tell ourselves some sort of story that the recognition of what's legal or illegal is necessarily a legislative power only. And in fact, I think the history tells us the opposite.
Hi, I'm Jeff Lubbers from American U. I really liked both of your presentations, and Carissa's yours is really illuminating to me. We've always heard a lot about problems with too much discretion in agencies, but who has more discretion, as you point out, than prosecutors? Maybe the police department, but that's another agency. And I think there's a good argument that both of those agencies should provide more guidelines and tell people how they actually enforce. And just one quick example, in Maryland, in Montgomery County, we know that we can speed up to 11 miles over the speed limit because that's what the traffic cameras are set to, and that's well known. But anyway, for Brenner, my question is, when we're talking about a regulatory violation, a lot of statutes do provide for both criminal and civil penalties. And I'm just wondering why we shouldn't be less concerned about the delegation of criminal penalties to agencies, because they can't adjudicate those. They can adjudicate civil money penalties through an administrative adjudication process plus judicial review. But if they want to charge somebody with a criminal offense, they have to send it over to the Department of Justice, and then it's a criminal proceeding with all the Bill of Rights attached. So, agencies are probably not going to do it except in the most egregious cases. And I'm really curious, did anybody prosecute that Vermicelli case? I mean,
I don't know.
I mean, there are a lot of things on the books that are never prosecuted, so it's pretty easy to make fun of those. But so that's my main question.
Yeah,
for you.
that's interesting. I do think many people have responded to the paper by saying, well, $1 billion fine is worse than 1 day in prison. But I do think there's a categorical difference between criminal and civil sanctions. I mean, right, and we have, I think the ABA keeps a whole list of collateral consequences. I know Roger Stone was really annoyed that the FBI showed up to his door at 6 a.m. That couldn't happen with a civil penalty. So I agree with you that the agency is going to be less enthusiastic to proceed criminally by handing it over to the DOJ because it no longer has authority over the prosecution. But I think it's more problematic for the reasons that inhere in the criminal sanction, right?
And I'd add that the threat of criminal prosecution gives civil enforcement more leverage, right? I'm not going to fight this in agency adjudication. I'm not going to seek judicial review of my adverse agency decision, and we're going to sign sort of a non-prosecution agreement, which I get are in the news now, right? We're going to sign a non-prosecution agreement in which I give up my right to these administrative challenges, and in return, get assurances that the United States government won't try to come after me with a criminal conviction.
Right, look at the Foreign Corrupt Practices Act. I don't know if anyone is familiar with this statute, but I did doc review at a big law firm related to the issues related to the FCPA. There are like 2 circuit court cases on this. They don't have to proceed criminally.
The Scalia Center had an evening session earlier this month about administrative law judges, where you essentially have the agency write the regulation, call you into their court as somebody who's violated it, and have an administrative judge apply the penalties, all within the same agency. I'd be interested in your comments on that. But I'm also concerned with the poor bastard who falls off the tour boat in the Potomac. Is he now criminally liable for swimming back to the boat? Or there was a young hero named Skolnick who dove in to save somebody when that plane crashed into the Potomac. Is he now a criminal as well?
I actually learned that Michael Ullman in the 60s was caught by an oar while rowing on the Potomac and was in the Potomac, learned this at dinner, back when the bad old days. But yeah, I think the question about the mens rea of these violations, many are strict liability, so that's a problem. I have no comment on administrative agency procedures. I sort of don't know. I guess to the extent that you think that this is problematic, that maybe the due process norms of the adjudication are lowered in an agency, well, that's because...
Violated is the word you're looking for.
Right, at least they can't throw you in jail, right?
Yeah.
Yeah, and I mean, I'd say I'm no expert on Article 3, but I'm married to one, and he would tell you that the erosion of what is considered to be the exclusive province of Article 3 is a serious problem in this country, and it's one that we just sort of take for granted. And it's the same sorts of arguments that you hear about plea bargaining, right? And the same sorts of arguments that Grassley gives us, which is we need a nimble system, we need an efficient system, that caseloads are too large to have Article 3 judges and juries dealing with all of these sorts of things. These things are definitely related to one another, and the question is just, do you want these things to happen expeditiously? Do you want to pay for a big enough court system to have them happen, I would say, constitutionally? I think for a lot of people, the answer to that second part of that question is no.
Yes.
Grassley's sounding like Woodrow Wilson from our lunch.
I'm afraid my question is going to sound a little Wilsonian too, because I work with a number of highly technical regulations. So an example would be regulations on how gas masks in nuclear power plants need to be tested and calibrated and maintained. And that's not something that is obviously absurd, nor is it obvious to me that democratic input in writing those regulations would have value or even be safe. Same thing with input from judges who are generalists. So I guess that's part of my question. Does democratic criminalization really apply to highly technical, yet potentially highly dangerous conduct? And as the gentleman down there already pointed out, most of what I'm thinking of is enforced via civil penalties, but it's not clear that the line between civil and criminal is clear, or that the civil penalties are always less bad. Thank you.
So I'm really glad that you asked that question, because I think it gets at something that came up during lunch as well, right? People are like, ugh, clean water, we can't delegate that. But safe drugs and safe food, like, yeah, sure. I mean, I think that there is a sense that there are questions about which we need experts to make those sorts of decisions. Personally, I have to say, I'm not sure that I see a huge difference between clean water and safe drugs. I think they actually seem pretty similar to me. And as a general matter, like, I'm on board with the administrative state making the world a better place and a safer place. My question is, at which point does the criminal law get involved? It's not just that you can have civil penalties for people not having the appropriate masks, but in my opinion, you would only have the criminal system get involved if there's harm that flows from that, right? So if we spent less time trying to use the criminal system to regulate all of the behavior that we think might be risky or problematic, so you can have regulations that make clear when those masks are necessary, what they have to look like. There can be inspections to enforce them and to penalize people through civil penalties for failing to do that. And then it's only if somebody gets hurt that you would then have a criminal prosecution. And let's be clear, right? Like, you don't need fancy new federal laws to deal with people getting hurt in those situations. Like, somebody dies from that and you're like, manslaughter, man. You knew there was a risk and you disregarded it and somebody died. So I think that the criminal system has a role to play. I think it just has a smaller role to play. And the making things safer stuff, I'm on board with that. I just don't think we should use the criminal law quite as freely as we do, or really very much at all, to try to make people safe. I think that we should use it to punish people once they've caused harm.
Right, I totally agree. Does anyone remember the limo disaster in upstate New York in the fall? So the owner of the company was charged with reckless homicide. for precisely conscious disregard of a substantial and unjustifiable risk. He could have also been punished with, I'm sure, some New York State DMV administrative crimes, but they just use the homicide statute. So
There was a
There's-
lady in the back, I think. Yes.
It sounds an awful lot like what you're saying is you don't believe in the prosecution of white-collar crime.
Me?
Is that anybody on the panel?
I mean,
Because white-collar crime doesn't always involve, obviously taking a gun and shooting somebody.
right, but yes, that's exactly right. Harm doesn't have to be limited to physical violence. I mean, embezzlement is a white collar crime, and yeah, that's right. Like, people should go to jail if they embezzle. I'd also add, right, like, I think that we probably avoid an awful lot of regulatory crime by having things like reporting requirements, making companies have external audits of their books and stuff like that. Again, lots of ways to avoid the possibility of crimes like fraud and embezzlement, which I think cause harm. And I think if you looked at the federal sentencing guidelines for white-collar crimes, like, that's how people get going to jail for so long under that, is because they calculate the harm, and it's hundreds of thousands of dollars very easily. So, I guess I would just distinguish between regulatory crimes that are about failing to comply with regulations that are meant to make people safe or meant to avoid the risk of future harms, whether it's intentional or accidental, and the concept of white-collar crime, which I think can very easily involve direct harm.
yeah, and I think it's a great question because one is tempted to think that these crimes, these regulatory crimes, administratively defined crimes, I should say, only affect industries that are regulated, but we have a great example this term that I don't think anyone considers sex offenders to be white-collar criminals. So they can reach down and touch pretty much anyone.
Well, thank you, Professor Hesse, Professor Fissell.
That was fun, wasn't it?
Thank you. Those were some great
Craig,
Thanks.